Hey, Boonies. Well, Sarah truly is the gift that keeps on giving, Clark, because they've uploaded what she sent to the court on these two motions. And of course, she couldn't just do the motions, she had to put her 2 cents on at the end of them. So we're going to read those today. And do you guys remember previously I'd said there was a 2 page document that had been uploaded to the docket and it was locked? Well, they've unlocked it. So we're going to do that one first. Oh, Sarah, you're such a pain in the ass. Oh God, this poor judge. Again, can we just take a moment, have a moment of silence for the prosecutor in the case? Seriously, you guys. I'm sorry. I'm not trying to make fun of the fact that someone lost their life. It's like, this is just freaking ridiculous. Okay. All right, let's get to this. Okay, August 1st, she writes it to Judge Cranick. Judge Cranick, I am unclear how the court had my correct address prior to you forfeiting my right to counsel, Sixth Constitutional Amendment, and forcing me to become pro se, and now does not. All my pertinent correspondence being delayed in my receipt of due to the court's error of sending to the wrong address now. This deters my fair and proper notice and any preparation required. Please correct immediately. Please also forward to whomever, change in portals, and correct in all correspondence tags or lists I am attached to and included in by this notice. I am expected no further hindrance or difficulties in this matter from the court's immediate attention and understanding of the importance to receive all correspondence timely and appropriately. You like how she puts my address as follows? Exactly. God, this woman needs some emojis for her handwritten stuff. Maybe she'll start drawing some emojis. Oh, and by the way, you guys, if you'd like to send Sarah a letter in jail, here's her address right here. Thank you for your cooperation. No more deterrence, please. The court is appreciated. Thank you, Sarah Boone. Pro se, indigent defendant. Oh, I'm going to do a video, you guys, specifically on just the jabs that she makes towards the judge. Oh, good gracious. All right, hang on. I need my lip balm for this one. Let's go over this other one. This is a motion that she did. Now, this is a 10-page motion, which they went over this in court already. She wants hard copies of the discovery submitted to the court by a former attorney for preparation of trial in her criminal case. Discovery definition, box A and B. The court will reach out to the jail to inquire how to deliver to the defendant and will provide written order to release both boxes. These two boxes, A, B, are the defendant's original discovery she has not seen in full to the present date, and it is her right to receive by law to fairly proceed in her defense. She wants to be able to inspect, copy, test, and photograph the following information: any tangible papers or objects that were obtained or belonged to the defendant, sanctions, willful violation by counsel or party not represented by counsel of an applicable discovery rule. I'm not going to read all this, y'all. This is all her basically copying out the legal things to make this motion fly, so to speak. Now, here she jumps in. Not unreasonable or unduly burdensome or expensive given the need of the case and the importance of the issues at stake in the litigation. She's basically saying the government is obligated under the Brady Law to disclose information in its sole purpose that is material to the issue of guilt or innocence. The government places heavy reliance on the cases that hold information is material if there is reasonable probability that, had the evidence/discovery been disclosed to the defense, the result of the proceedings would have been different. She's getting ready for her appeal, y'all. Any documents or requests made intentionally unavailable to the defendant through discovery in the federal rules of criminal procedure are in direct violation of the defendant's due process with prejudice and shall not be denied, restricted, or deferred upon request by the defendant. By doing so, this constitutes an intentional misconduct warranting sanctions. By the court only providing digital USB discovery to be viewed solely on the laptop provided by OCCD and restricted to select times during the day only, motion for extended times in process without the necessary hard copies, the defendant is unable to A. Review, research, investigate, build her defense at any time, and numerous hours are ineffectual and wasted by not having access to the laptop and by not having the original hard copies available to use physically during the laptop's closed hours. B. Write notes, remarks, interpretation, explanations, make recordings, and of any kind. She makes a point here that both are available to be provided by the court. Due to the court's error of not communicating with the defendant, foremost to avoid presentation circumstances in the jail prior to the implementation of the order on June 28th and after the defendant's July 8th letter questioning the location of her provised hard copy discovery. Oh my God. She's basically just marking down here, this is what you guys have said you were going to do and you haven't done it yet. She's bitching about the fact she doesn't have her discovery. And she says, it's an obstruction of justice to withhold the defendant's original hard copy discovery that has been compiled for ongoing 5 years to properly, fairly, physically construct her rightful defense at all times necessary to her and on the sole independent decision of the court, as the defendant did not ask or suggest this USB only option, was not included in any decision making, collaboration, or equal agreement for USB only format to be received, and was never advised by the court prior to the implementation of only receiving a USB copies. The defendant was excluded and avoided in this incredibly restrictive decision. More digs at the judge. Time, consideration, and inclusion could and should have been made on the court's behalf to avoid present disadvantaged circumstances, and the defendant would not deprive of her due process and equal opportunities to correctly, fairly represent herself and succeed futuristically. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, to lawfully receive, review, utilize the original hard copy discovery, boxes A and B, submitted to the court by former attorney on June 28th for preparation of trial in her criminal case. By receiving the original hard copy discovery in addition to the USB digital copies, the defendant is capable of viewing all discovery information available in continuous preparation of her trial, enhancing her ability to thrive lawfully. She says she can have a success. If she says have a successful outcome, I'm going to scream. Let's see. Enhancing her ability to thrive lawfully in her forced by the court position of pro se and representation of self. Oh, look, she's got a new thing she's added to her little motions, her oath. Her oath. Sarah got an oath. She got an oath of office. You think she got that from Brooks? She might have. I don't know. Certificate of service. She hand delivered it to the court. All right. Let me see what else we want to look at. So that was the 10-page motion. Then there's a 4-pager here. Okay, this is the other motion. Oh, this is the one where she just wants the handcuffs taken off. Which, I'm honestly, guys, I don't see the problem here. It's little Sarah. They can't discriminate in any way on this case, obviously. But I think if she's going to have to sit there and write notes and all that and pass papers back and forth, they need to uncuff her. And please don't get mad at me for saying that. We want this woman, think about this, guys. We want this woman to have a fair trial. We want her to stay in jail where she belongs. It'd be funny. I just had a thought. This wouldn't be funny, but then again, it would be funny. Okay, what if something happens and Sarah gets, let's just say, this would not be funny, but what if something happens and God forbid the case gets dismissed or something? The funny part in that would be that Hooker had to spend over 4 years in jail. Is it 4 years or 3? I wrote this down somewhere. in jail up until that point. Let me find my notes. March of 2024 or 2020. Yeah, 4 years and 5 months so far in jail. Now that would be some justice on top of some injustice. But God forbid, let's hope that does not occur. I just don't know why these horrible thoughts come into my head sometimes. All right, let's see. She's basically just saying, she keeps referring to herself as a pro se indigent defendant. Do y'all think that she's going to read this like Brooks did when he started his morning off and the judge asked for them to introduce themselves to the court? She wants to be able to function equally and comfortably while using the courtroom. The defendant must be able to write, reach, turn papers, pick up objects, open documents, pass information, utilize laptop, all normal movements of the defendant's hands, and as a whole to freely, properly, successfully accomplish any task needed for the following. Okay, you know what I just thought about? The judge could have brought this up earlier. I mean, but at the same time, I'm surprised nobody brought this up earlier. But I guess this is only the second meeting they've had since she's been an indigent pro se. I said that with air quotes. Prior to the entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public witnesses of the court, as well as vigilant armed duties, also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled, unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective and court understanding of this performance obstacle for the defendant is also requested respectfully, seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, to be unshackled, unhandcuffed, and allowed reasonable freedom in movement to function equally, accordingly, and comfortably in the courtroom. Ooh, now she's added a certificate of service. Girl, she's reading up on all this law stuff. She's starting to add everything. Before you know it, she's going to be a pro. I want to read what else they put. Okay. Hang on. Oh, wait. Okay. You remember earlier where I said there was 2 locked documents? Let me share this tab with you guys. So this is still locked. So this is not the same thing as what she did up here. They just did a delivery of digital copies. Y'all, I'll read this to you guys really quick. We got time. All right, so the court minutes, status held, the court addressed several of the defendant's motions and set deadlines as it relates to exhibits and witness lists. The court will prepare a specific order with all deadline dates as what was stated on the record, including the cost for JACs. The court provided the defendant in open court a copy of the email dated 7/24 from Gina M. Giovanni, Captain Security Operations, and a copy of today's order setting hearing. Court witnesses sworn and testified: Christian Lake with JAC's investigator Billy Lane, representative from Prison Break Investigation Sergeant Donald Casey, representative from Orange County Jail. And then up here above that it says, the court advised investigator Billy Lane, representative from Prison Break Investigations, to release the thumb drive to Sergeant Donald Casey, representative from the Orange County Jail, in open court. Investigator Billy Lane also released the 2 boxes of discovery back to the clerk in open court. Defendant requested that the 2 boxes of discovery be released back to investigator Billy Lane. The court granted that. The clerk released the 2 boxes of discovery back to investigator Billy Lane in open court, and trial remains as previously said. So somebody was asking me about what's going on for Friday. Wait, hang on. And then they just did these motions for them. I'll open this. I've already gone over this, but I'll do it again. JAC upped from 5,000 to 10,000 for the private investigator. They gave him $1,000 to incur for, or they are authorizing $1,000 cost for his travel expenses. He's got a service rate of $50 per hour. If the defendant is convicted, the court is responsible for determining the amount of obligation to be imposed as a lien against the defendant for these payments. I like it. Then, this is the scheduling order and notice of all the hearings. So they've moved this trial case management from September 24th to the 26th. And the trial shall be held in this matter for the 3-week period. 3 weeks. They're giving it 3 weeks. Commencing October the 7th. No later than September 3rd, the state shall file with the court and provide a copy of the defendant's state exhibit list and witness list. Oh, that's right. And then they gave her till the 17th to get her exhibits and witness list. It says that the state's digital evidence will be reviewed with the state's investigator, the defendant, and the defendant's investigator no later than September 3rd. This evidence viewing can be done in advance of the September 3rd deadline. The state shall provide defendant a USB drive of the state's digital evidence at the evidence viewing. If this evidence viewing is completed prior to September 3rd deadline, the state shall file a notice indicating the date and location of the evidence viewing with the court and provide a copy to the defendant. So basically what happened there, if you guys did not watch the last video, the DA's investigator, that's right? Wasn't that who that was? Basically saying that, look, if I'm in there and then you have the prosecutor in there, you have witnesses of the court there, and we can make any kind of records that we need to make. And then also, I think it would be a good idea for them to also have Mr. Lane from the defense investigation there as well at that same time. And then they can put something on the record of what went on during that thing, and they can avoid the media. Again, I want them to avoid the media when they're doing this. I don't want them to do this in open court with a camera listening in. I want this to be a fair trial. I want her to go down. Okay, so that's the discovery they're discussing. But the physical evidence, so I guess physical property evidence that they have in the evidence room will be reviewed with the state and the defendant on September 3rd at 9 a.m. I've got to put this in my calendar because I don't know if I wrote that down. I don't think I did. Oh my. Lions and tigers and bears. Let's see. September 3rd. I did not write it down on my calendar. All right. September 3rd. Suitcase Sarah. If they show it, of course I'm going to have it on my channel. I don't want them to show it though, obviously. 9 a.m. is 8 a.m. my time because that would be Eastern Standard Time, so 8 a.m. Central Standard Time. But they're saying they're going to do it in the courtroom. The defendant shall provide to the court any and all written objections to the state's exhibits, including the state's digital and physical exhibits, no later than the 17th of September. And then, of course, like I said before, they've moved the September 24th trial to September 26th. And it says no later than 14 days after viewing the state's digital evidence, the defendant shall provide to the court a written exhibit list identifying any and all digital exhibits that the defendant may seek to use at trial. But they will allow her to extend that deadline if she shows a good cause, which she'll have so many excuses. Well, I don't know how I'm supposed to do this if you can't. I only have 15 minutes per call. And then it's a fee charge when they call out. I have to ask somebody to help me with the fee. I mean, my ex-husband doesn't have anything to do with me anymore. He's taken my son. They've rode off into the sunset together. And you, Judge Cranick, you have ruined my life. I am an indigent, and now I am pro se. I just want you to understand that. I just want you to feel what I am feeling right now. Before this trial begins, I want to give everybody a serious warning. You may want to go out and buy one of those blow up clowns that you get at the toy store. You know, the punching clowns. Or a punching bag. You could buy a punching bag. It's just a lot more expensive and you might hurt yourself if you're not used to it. So I said like the punching clown because, you can kick it and you can, I'm just saying, I might go get me one. You might can find them on Amazon. If I see one on Amazon, I'll do a product placement for you guys. So then after she does that, the state has to review her physical evidence no later than the 26th September. The defendant shall provide to the court the defendant's witness list identifying the names. Okay, I already talked about that. Okay. On August the 14th, this is the part where, and I just said something to someone in the chat about this in the comments because we were talking about whether or not this was a necessary hearing. Let's go down to August 9th since it's coming up first. That's Friday. That's tomorrow. Hello? On August 9th of 2024, 8:45 a.m. Eastern Standard Time, a hearing shall be had in the courtroom on the defendant's motion for the defendant's reasonable freedom of movement in the courtroom, blah, 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 blah. I don't know. I was thinking it was if necessary, but it sounds like they may want to put it on the record what the jail wants to do about her being shackled. And I keep thinking back, I'm like, wait a minute. Giovanni's on vacation until Monday. Wouldn't Giovanni need to be part of that? But I guess they might send Sergeant Casey in the place of Giovanni. So that sounds like they're going to definitely have that hearing. The one on the 14th is the one which is next Wednesday, which would be the one, if necessary, to discuss her motion to lawfully receive, review, utilize the hard copy discovery submitted to the court for preparation of her trial in her criminal case hand filed on August 5th. So, I don't know. I watched this trial. I commentated on it, and I still don't know. See, I'm as bad as Sarah Boone trying to learn all this stuff. Oh, wait, this is 12:30 my time. See, I'm trying to understand. I'm trying to get better. Oh, and for those of you that are worried about possibly missing her trial date or any of her hearings, it's a bank holiday on the 26th. That's the trial management conference. They go over the contacts involved with the protocol addressed by the court on July the 25th and provided to the defendant are as follows. The court further orders that every Monday at 9 a.m., commencing August the 12th, a representative from the Orange County Jail shall email all notebook entries in the IMS from the prior week. Now, when the IMS is, I guess, for every issuance of the laptop. Oh, I love it. How did I miss this when they were talking? I love this. Every Monday at 9 a.m., the court has to be notified and sent the sign in and sign out. That's what I'm thinking it is. It's like a sign in and sign out every time Sarah gets on the laptop and uses the USB device. I love it. That's awesome. Okay. I'm glad we looked at that. Thank you, Judge Kranick, for keeping everything so streamlined and organized and just easy to read. Certificate of mailing. This is where it was sent to her. Okay. Let's see what else. Hold on. Did we look at this one? Oh, this is her address correction. Let me pull this up. So she's like, y'all need to check, y'all need to fix my address. And again, she says Sarah Boone, pro se indigent defendant. The defendant is unclear how the court had the correct address prior to the forfeiture of her counsel. Oh, now she's saying, see, here she goes, victim. She's a victim. She might as well call herself, at this point, a sovereign citizen. She's starting to spew some of the sovereign language. The defendant is unclear how the court had correct address prior to the forfeiture of her counsel by the court and forced to become pro se and now does not. This incorrect address was not provided to the court by the defendant nor requested ever to be changed. It's a conspiracy, Sarah. all correspondence to the defendant by the court is being delayed in receipt of due to this error, which deters the defendant's real-time response, proper notice, and preparation of any requirement contained therein. The defendant is requesting the court please forward the correct address to all parties affiliated in her criminal case, including all portals, correspondence tags, and all lists the defendants may be attached to by the court. Please also provide all necessary documents for official record of address change to be filed accordingly by the court and in the court. By this motion, the defendant is expecting no further hindrance, difficulties, deterrence in the court's fair and proper correspondence to be delivered to the defendant at the following correct address. So let's make sure we got it right, guys. Here's Sarah's address. Oh, good Lord. P.S. No. Well, it kind of is. No, it's not. Okay. Please be advised also the defendant mailed by United States Postal Service this information by formal letter to the court on August 1st to emphasize the importance of this immediate correction to be made on the court's behalf and from the court's error. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honorable court, in conclusion, to correct immediately the defendant's delivery mailing address and forward to all parties affiliated in her care. And she lists the statute. The defendant makes the following oath. I'm just kidding. And even on the freaking postal service, she has to even put her 2 cents in on the freaking outside of the envelope. Really, Sarah? Really? Really? Do her like she did the whatchamacallit. All right, so we went through all that. So that's it. That's everything as of today on the docket. You are now up to date, everyone. You can live your lives free of worry that you have not missed anything in the Suitcase Sarah saga. I'm so glad y'all joined me. I really am. I'm having a good time covering this case because, like I said earlier, she's the gift that keeps on giving. And I think I've met some new friends here online. You guys, I've got a lot of new people joining us by covering this case. So I appreciate you. I see you. I read not all the comments. I try to read most of the comments. And I appreciate those that are so kind in the comments and those that want to pinpoint every single little bitty itty thing that I do wrong. Well, God bless you. God bless you, Karen.
I'm not a bad person because of that. Not my fault. Not my fault. Not my fault. I'm not a bad person because of that.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.